5 seconds to go. Start. According to the learned counsel, the appellant, having completed 3 months of continuous service as a substitute teacher, is entitled to reckon his date of appointment as 4th March 1990, since he now stands duly absorbed by the order of 2nd January 1998. According to the learned counsel, the appellant ought to have been absorbed as assistant teacher since he worked as a substitute assistant teacher and taught classes 11th and 12th. Her further alternative case is if he has to be only considered as absorbed under the category of primary teacher, then he should be entitled to the benefit under the master circular and should be entitled to reckon his service under clause 6 of the said circular. Learned counsel further contends that the order of this court in the case of the appellant dated 15th February 1996 should be read in conjunction with the order of this court in the case of Shrimati Jai Shri Deb Roy. Learned counsel lays particular emphasis on the fact that the tribunal in the appellant's case in OA number 209 of 1990 had wholly relied on the order. Reiterating para 4 of the said order, learned counsel contends that OA number 209 of 1990 of the appellant was dismissed for the same reasons that OA number 149 of 1989 was dismissed. Learned counsel further emphasizes the fact that in CA number 9000 of 1995 by order, this court in the case of Shrimati Jai Shri Deb Roy had specifically recorded that the judgment of the tribunal in OA number 149G of 1989 was set aside. Learned counsel further contends that even the authorities so understood the orders of this court, and it is for that reason that they subjected the appellant also to a screening before the screening committee before the absorption on 2nd January 1998. Learned counsel contends that having done so, there was no plausible reason to discriminate the case of the appellant when it came to the grant of relief regarding continuity of service on the ground that this court had not made any specific order regarding continuity of service. Learned counsel contends that the grant of age bar relaxation can only be understood as a grant of additional relief to the party concerned here. The learned counsel for the Union of India vehemently opposed the above submissions. Learned counsel defending the orders of the quotes below would submit that the claim for absorption as assistant teacher was totally unjustified. According to the Learned Counsel, the appellant was appointed in 1989 only as a substitute primary teacher in the pay scale of the primary teacher, and hence merely on the basis of the claim that some stopgap classes 11th and 12th were taken, no plea for absorption as assistant teacher could be justified. He defended the order of absorption and also contended that the authorities were justified in passing the order denying continuity of service for the period, since there was a clear distinction between the judgment of this court in this case and others in the case of the appellant. Drawing attention to the orders of this court in the case of Shrimati Jai Shri Deb Roy arising out of OA number 149 of 1989, Learned Counsel contends that in the case of Shrimati Jai Shri Deb Roy, there was a specific finding that the appellants in that case were entitled to continuity of service in accordance with para 5.1 of the Master Circular in the event the screening committee found them fit for absorption. Contrasting this with the judgment of this court in the appellant's case, Learned Counsel would contend that no such direction for granting continuity of service in the event of absorption was given in the appellant's case. Learned Counsel would contend that even factually the case of the appellant was different from the case of Shrimati Jaya Shri Deb Roy, inasmuch as Shrimati Jaya Shri Deb Roy was in service on the date of absorption while the appellant was not. This submission is seriously disputed by the other. Nothing much, however, turns on this last submission of the counsel for the respondents. We have considered the rival contentions and perused the records. We are of the view that the appellant's claim for absorption as assistant teacher in the higher secondary section in the pay scale of rupees 5,500 to 9,000 is not tenable. The appellant was appointed as a substitute teacher in the pay scale of a primary teacher. In fact, when he filed the first round of proceedings in OA number 209 of 1991, no plea was raised that he worked as an assistant teacher in the higher secondary section. Even when he obtained interim orders from the tribunal. It was only to the effect that the services of the appellant should not be dispensed with without the leave of the court. Stop.